All right. Well, thanks everyone for joining us this evening. I expect that there'll still be people coming in the next couple of minutes, but for those of you who are on time, we'd like to go ahead and get started. Welcome to Tenant Tuesdays, which is a series being offered by the Howard County Office of Consumer Protection in partnership with other county and state entities, focusing on what tenants need to know and tenants' rights throughout the month of April. This is can you go back? Thank you. I'm Leslie McDonald, and I'm the Outreach and Engagement Manager for the Office of Consumer Protection, and I will be taking questions in the chat and facilitating a Q&A at the end of the session. As I started saying, Tenant Tuesdays continue at 6 p.m. on the next two Tuesdays. April 21, we're focusing on rental assistance, and April 28, we're focusing on fair housing protections. Again, thank you for joining. Next slide. I'm pleased to have with us today to focus on tenants' rights and the Tenant Bill of Rights, Emily Button from the Maryland Office of Tenant and Landlord Affairs, and Beth Silverman, who's an investigator with the Howard County Office of Consumer Protection. And with that, I'm going to turn it over to our team. Again, please put your questions in the chat and we will address them at the end of the webinar. Thank you for being here.
Thank you, Leslie. My name is Beth Silverman. I'm with the Howard County Office of Consumer Protection. And for those of you who don't know that Howard County has an Office of Consumer Protection, I think we're very fortunate to be able to have one. This county does have an office that is out there to help all consumers. And since everyone is a consumer, we really do try and help everyone that we possibly can. We try and help by giving information and advice prior to purchasing, or if you have questions about purchasing things, we talk to people by phone, by email, in person. We also handle disputes. If you have an issue with a merchant and a problem with a consumer transaction, our office does try and help. We also do try and help with issues between landlords and tenants. Our office does oversee various consumer protection laws and landlord-tenant laws. And we also try and do education and outreach to the community with programs such as this. So if you need something, please feel free to give us a call or contact us in some way, and we'll see if we can help you. And with that, I'm going to turn it over to Emily to talk about her Office of Landlord and Tenant Affairs.
Hi, good evening. Happy Tuesday, everyone. I'm Emily Button, Partnerships and Outreach Manager with the Office of Tenant and Landlord Affairs for the state of Maryland, which is housed in the Department of Housing and Community Development. We are a newly created office. We've been in existence since fall of 2024, and we were created under the Renters' Rights and Stabilization Act that passed in October of 2024. And we are charged to reach out across the state to ensure that tenants and landlords are aware of tenants' legal rights, aware of how to report violations or get assistance if they think their legal rights may be violated. And we also refer to resources such as legal assistance and financial counseling. We help people identify the appropriate authorities if they are experiencing things like housing discrimination or negligence in repairs. We might help them figure out which code enforcement office or legal services provider or agency to reach out to about different things that they might need help with as tenants. Great. Next slide. Oh, and I think it's back to you, Beth.
Yep. So just to get started, in Howard County specifically, we actually are governed by two different landlord-tenant laws. There's the Maryland Landlord-Tenant Act, which oversees the entire state. And in 2018, Howard County actually instituted its own Landlord-Tenant Relations Act, which works in conjunction with the state act. So we've added on to some things specific to Howard County. And so our office deals with both of those laws and helps people with things that deal with anything that falls under either of those acts. To get started, for all landlords and tenants in Howard County, it's important that all landlords and all rental properties are properly licensed by the Howard County Department of Licensing, Inspections, and Permits. That office oversees to make sure that properties are up to county code and provides the licensing to the landlords. the landlord has to provide a copy of that license to the tenant or tell them where they can find it. So as tenants, it's always important to confirm that your landlord is properly licensed before you rent out any property. And Emily, back to you.
All right. And so what I'm talking about this evening is the Tenant Bill of Rights that our office publishes and updates annually. The Tenant Bill of Rights is required as of July 1st of 2025 to be attached to all residential leases in Maryland at lease up or at lease renewal. So if you're in an office signing a lease, they should also be giving you a copy of the Tenant Bill of Rights. If they don't, I'm going to ask for Leslie to put a link to the Tenant Bill of Rights in the chat so that everybody has access to it. It's available online on our website in 18 different language translations. And what the Tenant Bill of Rights does is provide an overview of key areas of landlord and tenant law, and it's intended to be more easily accessible and easier to read than the full text of all of the landlord tenant laws for the state. So it is a summary document. It does not create new laws or rights. It summarizes rights that already exist. It doesn't cover every legal right that a tenant may have. It doesn't include all the local county or city requirements, such as Beth noted that Howard County has some requirements that are locally specific that may go beyond what is required at the state level. And it doesn't replace consultation or getting assistance from legal counsel. It just helps people to know what their basic rights are and where to start. The Tenant Bill of Rights has several sections, and I'm going to touch briefly on each of the sections and highlight some of the things that are newer in landlord and tenant law as we talk today. It covers the application process, pet policy disclosures. The full list is here, but we're gonna touch on each of these sections. We can go ahead to the next slide. So one of the things that it covers is application fees. And this is going to be a theme, but in general, if a landlord is charging you for something, they should be charging you for an actual cost that they incurred. So if a landlord is charging a fee higher than $25 for your application, they need to be spending that on something like a background check or a screening by a third party that costs that amount of money. If they don't spend that application fee and a lease doesn't occur, they need to return that application fee if you ask for it back. If it's not expended on a screening cost, that's not if they charge it and they run your credit check and your credit check that they paid for comes back that you have poor credit. But if they don't spend it running that credit check, they have to give it back to you. Landlords also cannot both charge an application fee and ask you to separately pay for a background check or a credit check on your own. They can do one or the other, but not both. We also have a new law as of October of 2025 that landlords are required to include a written copy or summary of their pet policy in the rental application form. So you can know what a landlord's pet policy is and be able to decide if the apartment is suitable and if you'll be able to bring your pets or get the pets that you want to get. And they have to include any sort of restrictions or requirements that they intend to enforce, such as restrictions on breed, number of pets, type of pets, and any things like pet fees or pet rent. I will also note here when we talk about pets that assistance animals are not considered pets and are not subject to pet policies. Assistance animals can either be a service animal or an emotional support animal, and landlords can ask for documentation that supports a tenant's need for that assistance animal if the tenant's disability is not obvious. And they can also charge for damage to the unit that is caused by an assistance animal, even if they cannot charge a pet deposit for an assistance animal.
All right,
So,
so we're gonna, that's okay. We're gonna move on to talking now about some lease issues. So the Maryland state law says that properties where there's 5 or more units must provide a written lease. In Howard County, we really do encourage all landlords and tenants to have written leases. This is your contract that explains what the responsibilities are between the two parties, and having things in writing is always a better choice. Leases in general cannot include any provision that contradicts existing law. So the landlord and tenant cannot decide amongst themselves, oh, well, the law says this, but we're going to agree to this anyway. And if there is something in a lease that is contrary to the law, that section of the lease, not the entire lease, just that section of the lease, becomes not enforceable. One of the main things that a lease has is rent. So it goes over rent, when it's due, what is it? And it also talks about late fees. In Maryland, late fees cannot exceed 5% of the unpaid amount of the rent for the month. And it also has a section either agreeing to some sort of electronic communications regarding rent and things like that. If there is going to be electronic communication, it has to be agreed upon ahead of time. And then another section of the lease is the lease renewal. So at the end of a lease, either party can decide not to renew the lease. Maryland has recently put out a law that codifies how much notice the landlord has to give if the landlord does not want to renew the lease. For a yearly lease, that is a 90-day notice is required. If they are going to tell the tenant, we are not allowed, we're going to stop the lease at the end of the lease. For month-to-month leases or any term less than that, less than a year, it's a 60-day notice. There are a few exceptions to this, domestic violence situations, but very few exceptions, and the 90-day or 60-day notice is required. In terms of how much notice the tenant has to give the landlord, that is not specified in the law, but should be in the lease.
Leases as of October of 2024 are also required to break out if they have an automatic renewal clause where the lease changes over to month. Because tenants on a 1-year lease have more rights and requirements for longer notice periods and things like that than tenants on a month-to-month lease, it is very common for leases to state that a lease will convert to month if it is not renewed. However, if that is going to be upheld, that lease must break out that section where the tenant initials or signs right next to that section to acknowledge that they are aware of the automatic renewal clause. As we discussed, I think with regard to rent, landlords can also only raise rents at lease renewal, and they have to provide 90 days written notice for a year-to-year lease or 60 days notice for a month-to-month lease. So your landlord can't just raise the rent in the middle of the month or in the middle of the year at any time that they feel like. They have to provide proper notice. They have to let you know what that rent is going to be. And some jurisdictions have rent stabilization laws, but there is no statewide cap on rent increases.
And just to confirm, Howard County does not have any rent stabilization law at this time, so there is no rent cap for Howard County. And then moving on to the conditions of the units. So of course, the property must be fit for human habitation. So when you go, when the tenant sees the property, it has to have everything working. And if there is anything that needs to be repaired, the tenant really has to notify the landlord so that the landlord can go ahead and make those necessary repairs. But there has to have all the basic things that you would expect, the heat and the running water and working appliances and all of those things. And if for some reason the property does not have those things, the tenant does have the right to sue the landlord to make those repairs, or the tenant can go ahead and file for what's called rent escrow. And rent escrow is a court process. It is for very specific major things. Rent escrow is for things like heat, water, sewage, electricity, and pests. And for those very specific things, if you have issues with those things and the court agrees with you, you pay your money into the court, and the landlord doesn't see any of that money until after the problem is taken care of, or the court could decide that the landlord won't get some of that money and may decide otherwise based on it. But for those major issues, it gives the tenants a way to sort of go to court and make sure that the landlord is properly fixing those problems. When a tenant in Howard County signs a lease, they should be allowed to look at that unit prior to signing. If for some reason they're not able to look at the unit, maybe there's a renovation going on or there's still a tenant in it at the time that they're looking at it, then when they actually go to rent the unit, if they go there and all of a sudden it is not substantially similar to what they were told it was going to be, that tenant does have the right to either select a different unit or terminate that lease. So it's important that when you rent, you're being honest about what it is that's being rented. And as a tenant, you have a right to believe and take advantage of what they're saying about the unit that you're going to be renting. And always big questions are about when can a landlord enter the unit. So recently, Howard County had this in its law, and the state has now made it the law that a landlord has to give 24 hours advanced written notice if they're going to be entering the unit to make a repair, or if there's an inspection or some reason that they need to get into the unit. The state went a bit farther than Howard County and actually gave timing and said that they have to, that a landlord can only enter the unit between 7 a.m. and 7 p.m. Monday through Saturday. The exception to that would be as if it's a one-time thing and both parties agree that they will agree to a different time. In terms of entry and notice, the landlord is allowed to enter without that notice if, in fact, there is an emergency situation, such as a flood or a fire or something like that. So they don't have to give the notice for that. But for any other reason that is not an emergency, the landlord has to provide written notice to the tenant so that they understand and know that someone's going to be entering the unit.
Okay. And I will be talking a little bit about some of the new protections for tenants in the event that they are experiencing or believe they may be experiencing a problem with mold in their unit. There is some new state law that provides the tenant the right to request that the landlord test for mold if they are aware of conditions that they believe might be a mold health hazard. They are required to make the landlord aware in writing. I always suggest that people be rather specific and let the landlord know where they think the mold is, which specific area they want tested, and other details. When a landlord receives that request, they are required to test for mold. That means have a professional mold assessment company come out and assess to see if there is in fact mold that rises to the level of a health hazard. And the landlord is required to keep the tenant informed about the test results and repair process. And if mold that rises to the level of a health hazard or potential health hazard is found, the landlord should typically repair or remediate those conditions within 45 days. Next slide. I'll also want to touch briefly on the law requiring landlords and property owners to give a tenant an opportunity to purchase a residential rental property, which they intend to sell before they can sell it to a third party. So for certain residential rental property. This is residential rental property of 3 units or fewer. So single family homes, condos, duplex, triplex, something like that. The landlord is required to send any tenants a notice that they are selling the property and offer the tenant an opportunity to meet a proposed sale price or match a third-party offer if they intend to list the property for sale or accept a third-party offer while the tenant is still an active tenant, while the tenant is living in the property, so that the tenant can have the opportunity to purchase before they get a new landlord without any awareness of the fact that the landlord is selling the property. And the property owner is required to use a specific notice that they create with the state, which reports to the state that they are following this process with the tenant. And the tenant has 30 days from the time that the landlord mails the notice to respond to the notice. They have a protected window where they have the opportunity to exclusively negotiate with the property owner if they should wish to make an offer to purchase the property. If the tenant receives the notice and declines, the landlord does not have to wait the 30 days after the tenant declines. Once the tenant declines in writing, that's the end of their right of first refusal, and the landlord can move forward with listing or accepting another offer. The right of first refusal only applies to certain types of tenants. It does not apply to all the types of tenants that overall landlord-tenant laws for the state apply to. So it is specifically for tenants who are named on a lease and have been renting the property for 6 months. It's specific, again, to properties of 3 units or less. It cannot be waived or transferred. You can't give it or sell it to somebody else, but it can be exercised jointly. So you could buy the home together with a friend or a family member. It only applies to active tenants, not former tenants. So after you have moved out, if the landlord lists that property for sale, they do not have to go back to you and offer a right of first refusal from a property that you have moved out from. And there are certain types of sales that are exempted. Typically, these are sales by an estate fiduciary on behalf of an estate, court-ordered sales, bankruptcy sales, and some different types of sales that are, even if the property would otherwise qualify by size, that are excluded from being required to offer the right of first refusal. You can go to the next slide. So we already covered tenants can't transfer their right of first refusal to somebody else. And somebody can purchase the property if somebody wants to buy that property for the tenant. Somebody else can buy it for the tenant as long as the property is at least partly in the tenant's name. The tenant is a party to the transfer. And tenants may be able to agree if there are several people, for example, in a rooming house or a group house that is going up for sale. Tenants could either agree to buy it jointly, or if multiple tenants are interested in purchasing the property, such as in a group house situation, the landlord can accept the most favorable offer from among several different tenants who all want to make an offer. Go ahead to the next slide.
Okay, thank you for that, because that's a difficult, confusing topic, and we appreciate that Emily was here to explain it to us. Next, we're going to talk about some more things on the Tenants' Bill of Rights, and security deposits are always a big topic of conversation. We certainly get a lot of questions about them. And right now, the state has changed the law so that landlords are only allowed to impose up to a 1-month rent as a security deposit. The law changed a little while ago, and it's now 1 month. There are a few exceptions for this, but basically that's the new law, that it can only be up to 1 month. And that does not mean that the landlord can't also charge a pet fee or pet rent if they're going to have that, and that's part of their pet policy. But right now it's a 1-month fee. And then returning the security deposit. So what happens at the end of a tenancy is that the landlord has up to 45 calendar days to refund the tenant's security deposit plus interest. There is an interest calculator found at the Department of Housing and Community Development's website under the rental section. And that, so that we don't, because that the interest rate changes, it's on a variable scale. And so instead of having to remember that, there's a lovely calculator that does all the work for you. So the security deposit and the interest has to be returned within those 45 days, except if the landlord's going to be withholding any part of the deposit. And if the landlord does withhold that deposit, they must, in a letter or in some sort of written form, within those 45 days, tell the tenant exactly why they're withholding it with actual charges. I know Emily talked earlier about landlords only being able to charge actual charges, and that holds too with security deposits, that they can only charge the tenant what it actually costs them to fix the problem, and they should be able to have documentation backing up that cost. If a tenant moves out and those 45 days go by and they have not received either the deposit or a letter explaining why the deposit is being returned, then the landlord forfeits the right to withhold any part of the deposit. The tenant also at that point can decide that they're going to go to court and sue them for up to triple the amount of the security deposit. So it's in everyone's interest that the landlords actually go ahead and return that correctly within the 45 days. Now, there's sometimes where tenants need to leave early. And if a tenant does want to move out early and terminate their lease before the end of the lease, the landlord is required to what is called mitigate the tenant's damage. So that means that they need to try and re-rent that property. And that as soon as, in fact, they do re-rent that property, the tenant is then only responsible for the time that the property is empty. And this is true even if there's an early termination fee paid. So many leases have early termination clauses where they say that the tenant can give notice and pay a fee. Usually it's a month or two fee to terminate early. And there's a good reason to agree to that. If you have a long time left on your lease, a tenant might want to agree to that early termination fee because it ends your responsibility. Whereas if you just move out, you could be responsible for months of rent if they are having a hard time re-renting the unit or are able to do so. But if you do pay that early termination fee and the landlord, say you pay a 2-month fee and the landlord is able to re-rent it in, say, a month and a half, they then need to refund that extra half a month to you as the tenant so that they're not getting paid twice for that unit.
So I'm going to cover a little bit of information about evictions. Tenants can be evicted for various things. These usually include non-payment of rent, violation of lease terms, or staying after the termination of a lease, which is called holding over. Landlords must obtain a judgment of possession and a warrant of restitution before they can forcibly evict tenants. And landlords cannot facilitate evictions themselves by doing things like changing locks, removing property, or shutting off utilities. They have to have authorization from the court, and the sheriff or constable has to accompany them before they can do anything like change the locks or remove property. Next slide. There are also some new eviction protections. In Howard County specifically, landlords are required to provide 14 days notice in advance of a scheduled eviction date. This is a notice that the landlord must send themselves separately from any other notice that you might get, that the sheriff might post to the door. The landlord has to send their own notice. They have to send it by 3 different ways. They have to send it by first-class mail with a certificate of mailing. They have to also post to the door a notice and then take a time and date stamped photo to show that they were within the required period, that they gave the required period of time. And they are also required, if they have a phone number or an email address, to either text or email the notice in addition to those other two ways. A sheriff, before they will enforce an eviction, will ask to see all three forms of documentation that the person received the proper notice. And the notice is also required to include a statement related to the risk to somebody's property that provides the number for the court self-help center, and provides information of the risk that somebody could lose their property and if the eviction takes place on the scheduled date. The certificate of mailing is not the same as certified mail. A certificate of mailing is obtained at the post office, and it certifies that the landlord mailed the notice. It does not certify that the tenant received the notice, like certified mail that requires you to sign for it. So the landlord would then keep that certificate of mailing and present it as one of their pieces of evidence that they provided the tenant with the proper notice. And I provide our contact information here. We have an office of 3 staff, myself, our director, Elise Thompson, and our tenant liaison, Melissa Little. You are welcome to reach out to us by our hotline at this email address, otla.dhcd@maryland.gov. We help people individually. We answer our calls and emails, and we are happy to speak with you if you have more questions about any of these matters or need to know where you can go for support.
Thank you. And in Howard County, we put up a bunch of different options here just to let people know there's different offices in the county that handle different parts of landlord tenant. So the first thing is the Department of Licensing, Inspections, and Permits. And that's the office that licenses the landlord and also makes sure that properties are up to county code. So if a tenant has a problem, like a landlord isn't fixing a problem, or they feel that there's a problem with the unit that isn't getting taken care of, that's the office that they would contact about that sort of issue. Next is our Office of Consumer Protection. And our office is what you contact if there's a problem with the law, if there's a problem with the lease or security deposit, or anything that might be statute-based that isn't about habitability or maintenance issues. And our office will try and see if we can help resolve and mediate those issues between the two parties and see if we can fix that. And then finally, we have the Office of Human Rights and Equity, and they specifically handle discrimination issues. So if you feel that there's ADA compliant issue or another sort of discrimination that's happening in the property of fair housing issue, that's the office to contact regarding those issues. So that's sort of our quick overview of some really important parts of tenant law and some tenant issues. And so I believe there were some questions in the chat. Leslie, if you want to open it up to questions now, Emily and I are happy to answer whatever we can.
Great. Thank you. We just have a few questions. Okay. First question, what rights are there for the landlord when the tenant doesn't advise of repairs and the problems escalate? Want me to read it again?
Emily, do you want to take that?
Sure, I'll take that one. So when I do training for tenants, I always emphasize that tenants do have a responsibility to notify the landlord that a repair needs to be made if they are aware that there is a repair that needs to be made. And when I give guidance to tenants, I let people know that your landlord could hold you responsible for damages to a unit if there is some major obvious thing that goes wrong that creates a hazardous condition, creates ongoing damage. So if a toilet overflows or a window breaks or there comes to be a leak in a roof, the landlord, it is the tenant's responsibility that they should let the landlord know something that the landlord might not otherwise know if it is an emergency situation that's causing damage, that's causing hazards. So tenants do have a responsibility to let somebody know. And I always tell tenants you should make that repair request in writing, because it is not going to be a defense against something like non-payment if you never let the landlord know that the repair was needed. Landlords should also have, just as a best practice, some type of inspection or check-in process where they are doing routine reviews of the quality of units, not excessively, but frequently enough that they might catch a problem that the tenant might not have a way to be aware of. So it's a two-way street, but there's the tenant's responsibility isn't none. Tenants are expected to report repairs.
And the question really is, what are the rights of the landlord? Is there any recourse for landlords if the tenants fail to give a notice that there's something broken?
Well, they could charge the tenant for damages, because then the tenant would be at fault. If my toilet floods, say, and it creates water damage all in my bathroom or my carpet or whatever, I am not at fault if I call the landlord right away. However, if I call the landlord after a month has gone by, the landlord might be justified or be found to be justified in charging me some of the damage for not having reported that repair, because I would have at least a partial responsibility to be taking care of the unit, be aware of what's going on in the unit, be letting the landlord know.
Yeah.
Okay, great. Thank you.
I'll add a little bit to that.
Sure.
Just that it's true there isn't anything specific in the statute that says here's what the landlord can do if the tenant doesn't report. But most leases, and I would encourage landlords to have in their lease that the tenant is required to report the damages so that it's really specific. And then if they don't, another option is that becomes a breach of lease, and that you could look into sending a notice of violation, and even going so far as, if you have to do an eviction. I know that's not what landlords want to do, but that is an option that is available for a breach of lease.
Great, thank you. We still have time if people want to put questions in the chat. Let's see, the next question is, does an email count as informing the landlord, or should it be a written letter delivered to the landlord via the Postal Service?
My question to that is, for what? What is the notification going to be for? In general, email is considered for a formal response because it has a date and time stamp. And for most things, I believe, and I'll see if Emily has different thoughts. Most things now we consider email to be reasonable. Text we still don't think is as reasonable, but most things are okay by email.
The one thing that is, I believe, specifically carved out, that tenants have to send formal mailed written notice to absolutely have their right protected, to be present for a move out walkthrough inspection. So one of the best tools to make sure you get your security deposit back is to make sure that you request to be present for a move out walkthrough inspection. And there is a formal tenant request process that is outlined in the law where you have to send a formal mailed request to guarantee. Now, most landlords don't require that. Most landlords, in my experience, are happy to schedule a move-out inspection when you can be present if you simply email them or request and make yourself available at a period of time. But you do have a protected right to be present. They can't deny you the right to be present if you send a formal written request 15 days in advance of your move out.
Great, thank you. That's all the questions that we have. One person commented, "Thank you very much for the discussion and feedback, very helpful."
All right.
So I think if there's no more questions,
Yeah.
we can wrap it up. Any last comments, Beth or Emily?
Just there's a lot of stuff in landlord tenant law, and we do try and help as much as possible. So if you do come up with questions or need assistance in the future, please feel free to reach out to both of our offices for Howard County and or for the state.
Indeed.
Great. Thank you both for being
coming
here.
today. Okay.
And thank you everyone for joining us.
All right.
Good night.
Thank you, Leslie.